The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. As I do, please listen carefully. Sorry, something unusual is happening with the screen, and okay. First case is People versus Durley Marte. For the appellant. Hello? Can everyone hear me?
I can hear you, Your Honor.
Yes,
Oh.
I can hear you.
Okay, great. So I'll just call that again. I'm sorry. People versus Durley Marte. That's submitted. Sorry. Adelaide versus Sungold is submitted. Nelson L. for the appellant.
Your Honor, for the appellant, Jeffrey Blinkoff of Leventhal, Mulaney, and Blinkoff, 15 Remsen Avenue, Roslyn, New York. Your Honor, may it please the court, I would also ask if time allotted to me could be amended to 3 minutes as opposed to 6.
3 minutes.
Thank you very much.
Would you like any rebuttal, or is that just 3 minutes that you're asking for?
May I please retain the perhaps 2 minutes to argue, 1 for rebuttal, please?
2 minutes to argue, 1 for rebuttal. Okay.
Thank you so much.
Of course. Respondent?
Yes, Jeffrey Hobnacht from Wilmer, Cutler, Pickering, Hale, and Dorr for respondent Nelson L.
2 minutes?
Yes.
And the respondent for Nelson L.
Thank you, Larry Bachner, appearing on behalf of the child. I don't anticipate needing more than 2 minutes myself, Your Honor.
Okay,
Thank
2
you.
minutes. Thank you.
You're welcome, Your Honor.
People versus Michael Crum is submitted. Hoya Hopage versus West 30th is submitted. Broadway 361 Broadway versus Javier Morales for the appellant.
Good afternoon, Justice Renwick, Ethan Cobry of Schwartz, Slackus, Reich, Greenberg, Atlas. For the appellant, I think I had requested 3 and 2 for rebuttal.
3 and 2 for the respondent.
Good afternoon, Your Honor. David Tyler from Starr Associates for respondent.
3 minutes.
Thank you.
People versus Paulino Camacho is submitted. Carr versus de Blasio for the appellant.
Good afternoon, Your Honor. Richard Deering from the New York City Law Department for the appellants.
I'm sorry, your last name?
Deering, D as in David, E-A-R.
Yes. Okay, 10 and 2. And for the respondent?
Good afternoon, Your Honor. Alvin Bragg for the respondent from New York Law School.
10 minutes.
Yes, Your Honor. Thank you.
Smith versus Northern Manhattan for the appellant. I'm sorry, that's submitted. I apologize. People versus Randolph Jameson for the appellant.
Michael Confucione, Your Honor. 4 and 1, please.
Okay. For the respondent.
This is Michael Yetter for the people, Your Honor. 4 minutes would be excellent. Thank you.
Great, thank you. Comptroller of the City of New York versus the City of New York for the appellant.
Y. David Scharf of Morrison Cone for the appellant, cross respondent.
6 and 2.
Yes.
For the respondent.
Jeremy Schrader of New York City Law Department, 6 and 2, please, Your Honor.
6 and 2. Gomez versus Trinity Center is submitted. People versus Mason McAllister is submitted. Advent Software versus SEI Global Services is submitted. People versus Matthew Williams for the appellant.
Good afternoon. It's Nick Talke, a law intern with the Office of Appellate Defender.
5 and 2 for the respondent.
This is Michael Yetter again, Your Honor, for the people.
Thank you. 5 minutes.
Thank
You
you.
have double duty today. Okay.
Yeah.
Everyone, all counsel, please remember as always that we have your briefs, we have your record, we're fully familiar with the facts of your case. So please go directly to the most important points that you wish to make this afternoon. Also, as is customary, please don't speak when a justice is speaking. Of course, this is particularly important during our virtual arguments, so that we can hear one another and that you can hear the questions that are asked. And finally, please keep your mics muted. Only the person who is speaking at the time should be unmuted. And thank you for your patience and your cooperation. The first case is Nelson L. If you just give me one moment. Okay. You may begin, Mr. Blinkoff.
Thank you very much, Your Honor. And may it please the court, my name is Jeffrey Blinkoff of Leventhal, Mulaney, and Blinkoff, 15 Remsen Avenue, Roslyn, New York, on behalf of the appellant. Preliminarily, I did want to apprise the court, and this is with the knowledge of my adversary, that there was a recent circumstance in this matter. On May 19th of this year, 2021, the Honorable David Kaplan in Family Court, Bronx County, following an inquest after a newly filed petition, verbally terminated the respondent's parental rights to the child. A final order has not been signed by that court as of this date. The matter is next adjourned to tomorrow to address a remaining issue as to a notice father who under the social services law would have the right to be heard as to best interest, but the respondent mother's rights were terminated following that inquest. In terms of the pendant appeal, the points that I would like to make essentially are the following. Briefly, that under the social services law, the lower court, I would respectfully submit, did not follow the directives of the statute or the case law to the extent that permanent neglect is written in the disjunctive. The statute is written in the disjunctive such that permanent neglect may be found either based upon a failure to plan or a failure to...
Judge Kern, I'm a little confused.
Yes.
Is this appeal moot based on what occurred?
Thank you for that question, Justice. I would respectfully submit no for two reasons. One, there isn't a written order. I should let the justices know I contacted the clerk of court as to whether we should notify, and I was advised that without the written order, we should not. There remains the opportunity for the parent to move to vacate the default. And I would respectfully submit that while that opportunity remains open to the respondent, the current appeal has not been rendered moot. And may I continue?
Yes. Mm-hmm.
So my argument is that the lower court did not respect the disjunctive nature of the statute. Secondly, I would like to point out that to the extent that there was reliance by the respondent upon cases to the effect that they were arguing that the plan was not appropriately tailored, I would respectfully submit that those cases such as...
Counsel, this is Justice Moulton. I want to interrupt you.
Yes, sir. Yes.
So the trial judge found that the agency's efforts essentially were perfunctory, and it therefore did not make diligent efforts to strengthen the bonds between the mother and the child in the relevant period. A couple things I want to ask you about.
Yes.
The caseworker, Ms. Lewis, did not know that the mother was on medication for mental illness until the mother told her that she had to go off the medication because she was pregnant. Isn't that a sign that maybe that that caseworker, and no criticism meant, but was not being diligent?
Thank you, Judge. I'm sorry that the camera, I wasn't sure if you had finished your question.
I had.
I certainly take the court's point. I would respectfully submit that the purpose of having arranged for the respondent to attend specialized services such as therapy and counseling would be so that those professionals could work with whether that respondent in terms of adjusting or determining whether or not medication would be needed, as opposed to Ms. Lewis, who is in the capacity of working to design a plan for her.
So let me just follow up on that.
Yes.
If I could, Mr. Blinken, or Blinkoff. Ms. Lewis also sort of took it on the mother's say-so that she was in fact enrolled with the program that she said she was enrolled with, the graduate program. The name escapes me entirely. Should Ms. Lewis have been more diligent and making sure that she was indeed enrolled in that program?
I think the program was the postgraduate program, Your Honor.
Yes, thank you.
What I believe is also in the record is that Ms. Lewis did make attempts in order to do just what Your Honor is indicating, but was unable to receive sufficient contact information for the purpose of doing so.
Please continue.
Oh, thank you. My point is that with respect to the cases such as in the matter of Xavier Blade and the other cases cited by the respondent, they do not specifically bear upon the case here, because here we have a circumstance in which the respondent had services available but did not cooperate with them. And also, unlike Xavier and unlike the other cases cited, the respondent was not cooperative with the plan that was in place. In Xavier, this court's decision in Xavier, the additional feature is that it was a very specifically honed and focused need that the respondent in that case had. Amicus Curiae also filed briefs with respect to that issue, and it focused on the intellectual disability that the respondent had and the need to have addressed that by the agency. And that unlike here, there was a very specific referral possibility through OPWDD that was not put in place, although that was something that had been clearly identified as something that the respondent could or possibly would have benefited from. And I would respectfully submit that because of that circumstance, that the court's determination in Xavier Blade does not bear upon the circumstance here, and that this court should respectfully reverse the lower court's determination to the contrary. I would also just respectfully point out that as I argue, particularly in the reply brief, so I won't read to you what I've already written, that there is reliance by the respondent in their papers on cases for the purpose of tailored services being provided that are vastly different from the manner in which services were available here. Again, and just as a quick example, the case of, in the matter of Jesus, which is at 223 AD 2nd, 955. In that case, there was a very unique circumstance in which the respondent involved in the appeal was being provided with services that were in fact services really necessary or needed for her partner. And that is not the circumstance here. Essentially, we had a respondent here for whom services were designed. The plan was in place. All she needed to do was to attend those services.
Thank you, counsel.
She did not do so. I thank you for your time.
Yes. For the respondent, Mr. Habernick.
Your Honors, and may it please the court, I want to begin by saying we agree fully with Judge Gomez's detailed conclusion of this matter that the agency failed to meet its clear and convincing burden on trial. However, I want to start first by discussing the mootness issue, as it's a jurisdictional question. Our understanding is that the matter is moot. The issue below was decided through a default judgment, which is final and unappealable. So given that Nilsa's parental rights as to her son Nelson, the same rights at issue in this appeal, have been terminated by a final unappealable decision, we believe the appeal is moot and the court does not have jurisdiction. It's true that Nilsa can still seek to set aside the default judgment. However, the situation is only hypothetical, and the Court of Appeals has stated that courts are prohibited from ruling on merely hypothetical questions.
What effect Not the fact that there is no written order, though. We don't have anything before us that we could rely on in making a determination to accept or not accept your argument.
That's fair, Your Honor, and I'm not counsel for respondent in that matter, so I can't speak directly to it. And so moving on, in the event the court finds that the appeal is not moot, the court should reject the agency's petition and affirm the family court's opinion. This is not a closed case. The family court resoundingly concluded that petitioner failed to meet its clear and convincing burden at trial. To quote the family court, it is without question that the agency failed to meaningfully and diligently discharge its obligations to provide diligent efforts from January 2013 to July 2014. And there's ample support in the record for the family court's conclusion. To begin with, in Nelson's first year of life, Nilsa spent almost 8 months incarcerated, during which time the agency only arranged for 2 visits between Nilsa and her son. This amount of contact between the mother and her newborn is unthinkable and contrary to the agency's own.
Wasn't part of that, though, because of some issue that she had in prison, that she was unable to participate in these visits for an extended period?
Yes, Your Honor.
That be attributed to the agency if it was based on her own actions in prison that caused that extended lack of visitation.
So thank you, Your Honor. I think you're referring to the suspension of the CHIPS visits, and 2 points there to be clear on. The first is that the evidence on the record suggests that the CHIPS visits were suspended across Rikers Island and not specifically as to Nilsa. And equally importantly, there's nothing to suggest that the suspension was due to conduct by Nilsa.
But even if it's true, how can you attribute any negative inference towards the agency for not arranging the visits if it was unable to arrange the visits?
Yes, Your Honor, and I would agree that during that period, that's understandable, but that was only 62 days of about 8 months of incarceration. So let's call it a quarter. And so during the rest of the time period, there were still only 2 visits within, I guess, 6 months, which is not their own policy of 2 visits per month. And additionally, I would point out that the agency had a lot of other options available to them to improve the relationship between the mother and the child. They could have given her updates. They could have sought her input on care. They did none of that. The only thing they did during the entire period of incarceration, which was like 6 or 8 months, depending on how you want to look at it, was provide her with 2 visits. And we would submit that this is not diligent efforts. And in another way, the agency has shown that it didn't provide diligent efforts is in the matter of mental health, which we've talked about. The reality is that the agency failed to provide Nilsa with the access she needed to mental health and did nothing to help her until 15 months after Nelson had been removed, despite the fact that the agency concluded that mental health was the primary obstacle to reunification. And finally, one last fact I want to point on this is the issue regarding kinship placement. So the agency completely disregarded the reality that Nelson was part of a larger family who wanted to and could have taken care of him. Specifically, the agency—
But counsel, I'm sorry to interrupt you, this Justice Moulton. The mother's sister did bring a custody petition in January 2013, but she failed to prosecute it, correct?
Thank you, Your Honor. It's true that eventually she abandoned it. However, I would point to the fact that that happened more than a year after she filed it. And the reality is that on the record, she abandoned it from frustration, resulting from the fact that the agency showed no interest in pursuing the matter, and it was just a source of frustration to her.
Where is that in the record in this case, if you can point us to some document?
Your Honor, I don't have that right in front of me. We're happy to submit a letter if it would be helpful.
Not necessary. We'll find it if it's there.
Those facts being what they are, we think that the agency's failures to exercise diligent efforts are unexplained and inexcusable, and certainly do not satisfy this court's standards for diligent efforts. And for these reasons we lay out in the brief, the court should affirm the family court's decision and dismiss the agency's petition to terminate this mother's relationship with her son. Thank you, Your Honors.
Thank you. Mr. Bachner?
Thank you, Your Honors. I won't repeat that which counsel has already stated, but I do adopt Mr. Blinkoff's arguments. I feel that in this record, I think Judge Gomez made it quite clear that she felt that her colleagues at the very commencement of this proceeding made determinations that she disagreed with. that she might have handled things differently. Yet nevertheless, in the many years that this case was before her, she never took any rehabilitative or corrective action. She could have placed the child with Aunt Michelle. There were many things that the court could have done. Waiting 6 years to complain about how the case was handled by her predecessors is not, in my opinion, a sound determination. I think Judge Gomez took a very harsh definition of the clear and convincing standard. I think that this case is much more in line with In re Adam D., which I cited, a 2018 Second Department case, where on almost identical facts, the Second Department reversed Judge Richroth's dismissal of a petition, reinstated the petition, entered a finding of permanent neglect, and terminated parental rights. That is what I would ask this court to do on this petition. For all purposes, these foster parents are Nelson's parents. He knows them as his parents. He has an idea of MILSA in the abstract. It serves no purpose to delay permanence for this child. Thank you, Your Honors.
Thank you. Mr. Blinkoff, you have a minute, if you'd like.
Thank you, Your Honors. Yes, please. I will respond first to the question of kinship resource exploration. I would respectfully submit that in the record, it's much more possible that the reason that the sister Michelle withdrew her petition was based upon perhaps frustration with her family. The respondent herself, as is seen in the transcript, July 24th of 17 at page 60, advised the agency she did not want the child to be placed with either the child's father or with any other member of her family, which would have included Michelle. And I would respectfully submit it's more reasonable to presume that that's why Michelle withdrew her petition, but I can't speak for her. I can say, however, as has been indicated on the record, that she did withdraw that petition. Secondly, while I note and respect counsel's statement about what the agency did or did not do according to counsel while the respondent was incarcerated, I think that ignores the point that, for example, from April of 2013 through March of 14, when the respondent was out of prison, was able to visit, that she did not take up the opportunity to do so, that she attended approximately 29 of 50 available visits, which is found in the transcript, page 47 on May 2016. When available, when at liberty, when given the opportunity to visit, the respondent mother did not take that opportunity. And I therefore return where I began, which is visitation is a separate basis upon which to find permanent neglect. I thank you for your time.
Thank you. Thank you. My thanks to all of you.
Thank you, Your Honors.
Next case is 361 Broadway versus Javier Morales.
Thank you, Justice Renwick, and may it please the court. Summary judgment for a plaintiff before discovery, really? In granting the sponsor's pre-discovery summary judgment motion, the trial court overlooked Morales's well-pleaded defenses. It engaged in issue resolution, not issue finding. It drew inferences of its own, favoring the sponsor, the movement, over Morales.
Counselor, this is Judge Singh. What issues of fact have been raised by your client?
The primary issue of fact here is during the fleeting 14-day rescission period where my client had the uncontestable right to rescind this deal, he was peppered with multiple misrepresentations about the status of construction of the building.
So in other words, what was going to occur in predictions of what was going to occur in the future?
No, I'm sorry.
Go ahead.
Respectfully, no. Yes, there were some predictions about what would occur in the future, but there were also misrepresentations of then existing facts. So for instance, Your Honor, at page 759 of the record, the sponsor's counsel writes, sponsor is very close to TCO. That's not an expectation of what will happen.
Was that within their control? Was that within the control of the sponsor? I mean, wasn't that, within the control of the city or the agency that was going to provide that document? How could they really know?
The precise date was certainly within the control of the city agencies having jurisdiction. The issue is the misrepresentation wasn't about when it was going to be issued. The misrepresentation was, we are close. And in fact, what's even more egregious than that is if you look at
But
page.
tell me something, Counselor. I'm sorry to interrupt you, but at the time the rescission notice was sent out, how many months behind schedule was the project?
It was, I think, a few months behind.
Well, I would submit that it was closer to 20 months behind schedule. So under those circumstances, how, even assuming you're correct that there was a misrepresentation of fact, how was reliance reasonable?
So number one, reliance was reasonable because my client was receiving written affirmative misrepresentations. And yes, after 20 months of delay, when my client has 14 days to rescind, to receive misrepresentations such that we are down to last inspections, page 799 of the record, that is not inconsequential. And he was certainly entitled to rely on the sponsor's representations. Moreover,
this is Judge Kern. Wasn't there an extensive period of time, even after the 14-day rescission period, where he could have spoken up and said, I want out of this deal, and that he did not speak up for quite a long time after that 14-day period? And would that obviate any reliance on that 14-day period passing by?
Justice Kern, your point is well taken, but it wouldn't, I don't believe it would obviate I don't think it would negate, I should say, the sponsor's affirmative misrepresentations. Mr. Morales continued to preserve his objections as late as December of 2017, when he objected to proceeding with the closing for all of the reasons that we've raised in our affirmative defenses in this case. So what you have is, you have multiple misrepresentations. I don't think there's any question about that. There's no question that these representations by the sponsor were false. We have them all occurring during this really brief 14-day rescission period. And then perhaps most troubling of all is we have the sponsors, I'll call it an ever-shifting story about what really happened. So at around the time that this all occurred, the sponsor wrote to my client saying it had to make a change in the construction manager because they were unhappy with the speed of construction. I'm sorry?
Isn't it undisputed that there was no closing date set in the agreement, and specifically said there's no outside date for closing? So how could it be a misrepresentation if that date kept getting extended, where there was an affirmative representation that there wouldn't be a date set?
That's exactly the trap that the sponsor, I'm sorry, it was just catching. That's exactly the trap that the sponsor wants you to fall into. This isn't about when the closing occurred or representations about when the closing would occur. This is a representation. This is a case about a misrepresentation about the then current status of construction. So let's play out a scenario. If I was told by the sponsor—
After your scenario, we'll come back to you. Your 3 minutes is up. After your scenario, we'll come back to you. You have 2 minutes rebuttal. Go ahead.
Okay, so here's the scenario. In January of 2017, I have 14 days to rescind, and you're telling me that construction is really close. We're down to, quote, last inspections. So you know what? I think to myself, okay, construction's almost done. As Justice Singh pointed out, we've waited 20 months. We're almost there. I can hold on a little bit longer. Turns out that was a misrepresentation of then existing fact, and it induced me to not trigger those rescission rights.
Thank you. Let's hear from Mr. Tyler, I believe.
Yes, good afternoon. If it pleases the court, David Tyler here on behalf of respondent. There are a couple of things that appellant's counsel mentioned today that we strenuously object to. The first being that there's any trap. These agreements and these transactions are highly regulated. The Attorney General, going to the delay that there was here, the Attorney General sets 1 year periods during which there's a required rescission period. And in fact, when this closing finally took place in December of 2017, 11 months after the alleged misrepresentations, there was, within roughly a month after that, there would have been another rescission period. Appellant chose not to take advantage of the rescission periods, and in fact is using these claims, which are false.
Counsel, let me just interrupt you for a minute. The defendant or respondent, defendant, had one adjournment, right, of the closing? It was allowed. It was allowed under the relevant documents, one adjournment of the closing. Is that right?
That is correct, Your Honor. In fact,
So it did adjourn. It did take advantage of that. It went from December 7th to December 14th at the behest of the defendant, correct?
That is correct, Your Honor. In
And
fact,
so you're arguing that they could have put it off for even longer and waited for the next rescission period.
they could have put it off longer. They didn't ask to. They didn't ask to rescind at any point. And in fact, they agreed to the scheduled closing on December 14th of 2017 and just didn't show up. There was no objection to closing, as counsel said. They simply did not appear after agreeing to their adjourn date of the closing.
Any other questions?
May I continue?
Okay, I'll give you 30 seconds to wrap up. You've already
Thank you.
met your time.
Thank you, Your Honor. Appellant's arguments are simply a miscast and a recast breach of contract claim. They have no breach of contract claim. The contracted issue provides damages to the plaintiff. Their arguments are duplicative and barred by the existence of that contract.
Thank you.
Thank you.
Mr. Cobrey, we're back to you.
Thank you, Your Honor. My friend says that there was no trap. Respectfully, that's an issue of fact. And this goes to Justice Singh's point of earlier about justifiable reliance. Maybe yes, maybe no, but without Mr. Morales receiving any discovery or any opportunity to obtain discovery in this case, we'll never know. My friend says that we didn't object in December of 2017 to the closing. I would respectfully point Your Honors to pages 819 and 820 of the record, where we do in fact object to the closing in December of 2017. And I don't want to belabor the point. If Your Honors are so inclined to look at anything in the record, I would respectfully ask you to compare the following three record citations: 901, 23, and 879. 901 of the record, the sponsor is saying, we made a change in the construction manager as they were unhappy with the speed of the construction process. And yet in this litigation, that story changes. On 23 and 879 of the record, it's made very clear by the sponsor in this litigation that the construction manager or the general contractor unexpectedly quit. That those are conflicting stories. It goes to the heart of what the sponsor knew during this 14-day rescission period. And respectfully, we think that on this pre-discovery summary judgment motion for a plaintiff, that this begs for a modification of the trial court's order.
Thank you. Thank you both.
Thank you.
Thank you.
Thank you. Matter of Gwen Carr versus Bill de Blasio.
Thank you, Your Honor. May it please the court, Richard Deering for the city. The events surrounding Mr. Garner's death are serious. They are tragic. Those events have prompted investigations at numerous levels of government. They've prompted extensive reporting and public discourse, significant reforms. Significant misconduct has been found. The police commissioner fired Daniel Pantaleo. He disciplined a sergeant.
Counselor, this is Judge Singh. I agree with you that there has been a fair amount of public disclosure. But how about with respect to the actions of the other police officers at the scene? Is the same true for those officers?
It is true, and for two major things to point out there. One is that we have extensive video recordings that have been widely viewed that cover essentially the entire course of that incident, including the actions of other officers. But more importantly, what I'd say, and it's really worth reviewing this, is the record of the departmental trial. There is a detailed and extensive record. Those officers all testified under oath. They were examined and cross-examined, and that testimony really, for reasons of narrative completion and others related to that trial, spanned the whole gamut. That includes the stop and arrest of Mr. Garner. That includes a frame-by-frame questioning of the handcuffing of Mr. Garner. It includes questioning of Officer Meems about a trained EMT, about the medical care he provided to Mr. Garner. It includes challenging questions to Justin D'Amico about his paperwork that he filled out. And all of those matters are discussed in detail. So it's not just that we have press reporting, public discourse, reforms, video.
But doesn't those things, don't the officer's conduct implicate the constitutional and statutory provisions that go into arrest and the use of force, even for and effecting an arrest, even for something minor? Aren't those really, I mean, you've indicated that, there's been a lot of cross-examination, a lot of inquiry into how long or what they did exactly, but isn't that the larger issue that's at play here?
I think that's the larger issue the petitioners would like to explore, and there are two reasons why that's not an issue for a Section 1109 summary inquiry. And the first is that the core purpose, really the only purpose, is to shed light on the facts. There can be no fact-finding, meaning the record. There can be no fact-finding, there are no credibility determinations, there are no legal conclusions. All of those matters of fact, testimony in some cases conflicting, most cases not, have been explored in detail in the departmental trial and in other public sources. In James, this court said that one of the reasons to deny an inquiry there, overruling the trial court, was that the matters were hardly hidden from public view, and the same is true here on all of those points. The second one I want to make, which I think is definitely secondary but still important, is and it relates to what I just said. A summary inquiry cannot produce a conclusion about whether there was probable cause for the stop and arrest. There are conflicting accounts. It cannot produce a conclusion. It cannot produce a conclusion on any other legal question. And so what we have here are not the kinds of things that James is alluding to.
Yeah, this is Judge Gunn. Aren't there a lot of issues that do remain unresolved, well beyond the issue of whether or not there was initially probable cause or not probable cause for the arrest?
But the others are all covered in the departmental trial. The conduct of other
issues of that many of the officers were not prosecuted, and why weren't they prosecuted? And many other issues which are the focus of what's going to go forward in this judicial inquiry.
Well, it's not. It's far from clear that that's the focus. There's a real shift in focus where sometimes the petitioners and the Supreme Court seem to be talking about the underlying events. Other times they seem to be talking about what I call, for lack of a better word, the sort of meta question of what response was taken, investigation, and discipline. But let me talk about that second.
But aren't those related questions? And so, for example, with respect to the alleged false filings, false statements, would you say that there's been extensive public discourse there?
Sure, there are at least, I counted 15 or 20 newspaper articles saying that Justin D'Amico exaggerated the top charge based on the public trial that I've just discussed. And a key point I want to make about that is the full testimony, which we describe in our reply brief, shows he filled out 3 forms that night of the incident. One listed a top charge of a felony, 2 others listed a misdemeanor. And the narrative description on the one charge was accurate about conduct that would describe a misdemeanor. What you've got is 3 documents, 2 were right, 1 was mistaken.
Well, mistaken or an alleged false filing. And isn't that the whole point of the inquiry? Is to flesh out the circumstances and what occurred?
Well, the circumstances are well known. I'd submit at some point we have to use common sense. If somebody fills out 3 documents and gets the point right on 2 and wrong on 1, is a mistake or a false filing. Some point common sense has to come into this. But the more critical points are, I think, are the circumstances have all been fleshed out first, and second, this summary inquiry by its nature, by its core nature, cannot yield a resolution on any question. Was it intentionally false? It cannot answer that question because there are no findings. And this gets to my second point. It relates centrally to your question, Justice Kern, about the investigations and discipline. And this really goes to James and what is a 3 or 4 page discussion in James about what is the proper scope of Section 1109? What are the predicate acts? What it makes clear, it applies to official misconduct, matters of misconduct, not mismanagement, not mistake.
And counsel, I'll stop you there. Isn't that what we're talking about actually? Is actually misconduct as opposed to malfeasance or something like that?
I'm hard pressed to see it on the question of investigations and discipline. There is a criticism that more should have been done, that others would have done more, perhaps. Some of that criticism may be well-founded, other parts may not be. But those are quintessentially matters of judgment. Those are quintessentially allegations of mistakes about the scope of the investigation, bad judgment about the scope of the investigation, maybe mistaken judgments about what to prosecute and how to do it. That is the kind of thing.
Are you saying that if they intentionally made decisions not to prosecute various of the officers for whatever reason, but it was an intentional act on the part, that cannot rise to the level of misconduct? Is that?
I think theoretically
that's
it
always
could.
going to be mismanagement. Then what is misconduct if that's not misconduct?
I think it theoretically could, if there was some basis to allege that it was some kind of deliberate dereliction of duty. But what we have here, there's nothing here that supports the idea that this is more than a difference in judgment about what should be done. And that is what James says is off limits. It says alleged deficiency in performance, alleged mismanagement. These are quotes. Alleged imprudence in judgment is not a proper subject for a summary inquiry. And I submit there's two key reasons for that. One is it is important to have a limiting principle on this type of inquiry. It is an unusual device. No requirements of standing, no elements, no motion, summary judgment, nothing like that.
It's an unusual device. It's an unusual tool in a highly, highly unusual case. And I understand you're painting broadly, but there are 7 different levels of inquiry, 7 different categories of inquiry. And for example, even the medical care that was provided to Garner, the leaking of the arrest and the medical histories. I mean, these are all things that they're asking for further development and inquiry into to ensure that it was handled properly. And you're sort of, generalizing a little bit in the way you're answering the question overall.
Well, I'll try to drill it down a little bit more. There is a very detailed public record on virtually the entire sweep of that inquiry, and our brief lays it out point by point. The questions of should more discipline have been imposed, should more have been investigated, those are classic James questions that are outside the scope. And I do think it's dangerous to say.
James really focused on whether or not it was significant. And I think these are significant. Were there violations or neglect of duty? Well, it seems like that further inquiry would be reasonable. And were they significant? Well, that's the question here.
I read James differently, which is significance is no question part of it.
Oh, I was on the case, so I know it was in the dissent, but I thought I
understood. It's a key part of it, but there is another key part, which is that it is about misconduct, not error. It is not about imprudent judgments, not about deficiency. It's not about mismanagement. Other cases make the same point. And it is a dangerous thing to say this case is too important, or the issue is too important to adhere to those objective limits that have previously been determined. This cause of—
To be clear, that's not what I was suggesting in my question, if you misunderstood.
I'm not trying to suggest that, but I'm just trying to make a point that I think is important to drive home for the city, for this case and other cases. And the last point I just make before sitting down figuratively is that and this relates to another key point. The fact that there will be no findings, it has independent significance, because what this is proposing is to ask a lot of questions that will have no clear resolution. This inquiry cannot resolve.
Counsel, this Justice Moulton, I understand that the petitioners want to do is look at the specific errors made here, misconduct shown here, and see if it is emblematic of systematic problems. And that's what I understand the hearing to be about, whether it can shed light on systemic problems in dealing with police violence.
I do not understand that to be the scope of the petition, that it's about systemic issues. That would even be, though, I would contend, there's no reason or predicate laid for the idea that there are systemic issues. That issue has not been litigated, was not litigated below, really is not litigated on appeal. This inquiry, as ordered by Supreme Court, is about the events of this case, what happened on the street that day in Staten Island,
Yes, I know, but I guess what I'm saying is that what Judge Madden did talk about was what came in the wake of these events. So in other words, did the commissioner, for example, look into the officer's understanding of probable cause in the situation? Did that happen or not? Obviously, there won't be any definitive finding on that, but there could be testimony on that question. Also, with respect to what happened to D'Amico after the records were filled out, and you told it correctly that there were correctly filled out forms as well, but did his mistake indicate some larger problem? I mean, those are the sorts of questions that I understand the plaintiffs petitioners to be looking into.
Well, can I just, I think the first one's a key one.
I'm going to just ask that well, I'm sorry, go ahead.
Sorry.
Yeah.
I'll try. So the first one's a key one because I think it highlights something here. What you have is, on the question of stop and arrest, probable cause, what you have is something you guys see in lots of cases that are argued before you. The officer says he saw something, the arrestee denied it. Others on the street, civilian witnesses, you can hear it narrated on the videotape, you can see it laid out at length at the departmental trial, said the officer was mistaken. The officers recover packs of unstamped cigarettes from the arrestee, including an open pack. Doesn't prove that what they saw was right, but is consistent with it. And that's just a factual conflict that cannot be resolved. And on these circumstances, the idea that there is should be an assumption that the police disciplinary process would kick into gear based on that conflict that we see again and again and again, when there are much, much larger questions that this case presented that were squarely at issue, investigated, and addressed, I just think is an unrealistic understanding of how it can operate. And the same exact thing will be reenacted in a summary inquiry if it occurs. You will see the testimony that's already occurred at the departmental trial of what Officer D'Amico says he saw, of what the witnesses on the street say actually happened, not consistent with that. D'Amico was challenged at that trial about what he saw. This is all emblematic of what the sweep of this inquiry will look like. We know the record has been created. We know what it is. The idea that anything
Why don't you,
driven
Phil,
forward.
you have 2 minutes rebuttal, so we'll hear more from you then.
Thank you, Your Honor.
Mr. Oliver, I'm sorry. Mr. Bragg, I believe.
Yes, good afternoon, Your Honor. Mr. Oliver is my co-counsel. May it please the court, my name is Alvin Bragg. I'm co-counsel for the petitioners, respondents. I'd like to start just where the city left off. It's not clear to me that the Pantaleo administrative hearing is properly before this court. It's raised for the first time here on appeal, citing to another case before Your Honor. But even if it is, it does not address so many of the questions that the petition seeks and that the Supreme Court ordered. Let's start with the false statements. Conspicuously absent from the city's argument today is, to me, one of the key questions here, which is Officer D'Amico filled out an arrest report and said that no force was used. There was no testimony that was not explored on his cross-examination in the hearing. And that's an essential question. Why did he make that statement? To whom did he speak before he made it? Was he aware that there was a video? These are the kind of factual issues that are not fleshed out. And I'm happy to go point by point because this is what we seek. We seek not an advisory opinion from the Supreme Court, but we seek that which Section 1109 is set up for, transparency, which in and of itself is powerful. The facts laid bare here is what we seek and what the Supreme Court ordered. So in the false statements, there is no testimony by D'Amico on his cross-examination about why he said no force was used.
What about, Counselor, the aid that was rendered or the lack of aid rendered to Garner after the arrest? Has that been explored in the administrative process?
Thank you, Your Honor. This is such a telling example. There was limited testimony about the taking of a pulse, but no testimony as to what I or the Supreme Court below would consider aid. And there's so many more questions that could be and should be asked. Why did not any of the officers provide anything more than checking the pulse? Was there discussion about that? It is interesting to note, I would underscore the focus of this proceeding was not about aid. It was about Officer Pantaleo and a hearing as to whether or not he committed assault in the 3rd degree or strangulation in the 1st degree. So it's not, I guess it's not untoward, or it's not shocking that these issues were not fully fleshed out because they were not before the court. What is interesting in terms of line drawing, and this may go more to the James issue, is that as to the EMTs, Justice Madden below, she drew a line and she said, the police, there's nothing put into the record, but the EMTs, the FDNY submitted an affidavit about the investigation that was done about the care provided there. So Justice Madden surgically carved out that portion from the inquiry. So I know I'm moving to the James inquiry there, but I think that's important just while we're on the care. The record is not developed in any real way as to the NYPD, and there's this void in the record. The city, which represented both the FDNY and the NYPD respondents, put in an affidavit as to the EMT care, but nothing as to the police. I would also talk about the leaks. I believe the city, and I'm sure opposing counsel will correct me if I'm getting it wrong, but I believe the city concedes that the leaks are not even addressed in the Pantaleo hearing. This is a very significant issue. We have the PBA president, Pat Lynch, having access to that which is sealed by law. And then the city, in response in its papers, first shifts and says, well, how could you ever investigate this? That was in their opening brief. And then we laid out a blueprint, much like Green versus Giuliani. Well, you start with Mr. Lynch and you work backwards, just as the Supreme Court did in Green versus Giuliani. Start with the then mayor who had the information and work backwards. And then they shift in the reply papers, the city does, and just sort of summarily says, well, this won't work under 1109. But these are the kind of core questions. Who had access to these documents? The city suggests that it could have been, I don't remember the exact number, but it's in the hundreds. That is shocking in itself. Records that should be destroyed or returned to Mr. Garner were accessible by hundreds of city employees. This screams out for the type of transparency that 1109 was put into the city charter for. If ever there was a case for the transparency.
Counselor, again, this is Judge Singh. Can you address the James issue? Your adversary seems to say it reads James, I'm sure differently than you do, maybe differently than I do, but how does this fall within James from your perspective?
So I would say, and I believe one of your honors, forgive me, I can't recall which one, talked about the interplay between what happened on the scene and the following investigations or lack of investigations. So what happened on the scene falls under the violation of duty part of 1109.
Official misconduct is what you're saying.
Well, yes,
violation of a duty, an infraction or a contravention of law or duty. That's what you're speaking about.
Exactly. Whereas the follow-up, the investigation, or we submit failure to investigate, is under the outright omission. And we list in page 33 of our brief the meticulous findings of Justice Madden below, where she goes point by point and shows that the city has proffered no indication of any investigation not relating to Officer Pantaleo. It is, marshaled. I don't want to repeat it for your honors, but it goes step by step into each of the areas that she orders and says the city hasn't proffered. So the city suggests that we want to find out, we want to micromanage, we want to second guess. This isn't second guessing. We have no clue as to the scope of any of these investigations. And I would respectfully submit the fact that they submitted an affidavit for the FDNY, but not for the NYPD, underscores our concern here that, in fact, there was no investigation, which is why there's an outright omission, which is why under James, even under the city's own reading of James, Section 1109 inquiry was ordered. And in a minimum, certainly there was no abuse of discretion for Justice Madden to so find. So I think under both the violation of the duty which happened at the scene, and I agree that they are interwoven as a matter of fact, that the exercise of discretion by Justice Madden was clear, and this is not something that has been publicly aired. And then as to outright omission, the justice marshaled in a way that it's hard to imagine having been done better. And if I could take a step back. And I appreciate the comments of counsel at the beginning as to sort of the underlying facts here. This truly is an extraordinary case. a questionable stop for which the facts are not fleshed out, followed by undisputably the taking of a life of an unarmed person, followed by 5 minutes where officers stood idly by and didn't do medical care, then followed by an undeniably incorrect statement. We submit false, but that's something that a summary inquiry could shed light on, and then adding insult to injury. Perhaps that's a bad phrase in the context of this death, but going a step further, compounding it, then leaks of confidential information. This is extraordinary. That the notion that this could open up floodgates is shocking, and in fact is counter to what the mayor himself has said. He said that he's working towards this never happening again. So petitioner respondents respectfully submit that Justice Madden was correct, and certainly at a minimum did not abuse discretion, and that was surgical in our application of the James standards, clearly digested that decision, carved out the EMT medical care issue, carved out the training, which petitioners sought, but we did not cross appeal on, and arrived at a meticulous, thorough, streamlined order requiring a summary inquiry, which really, if ever there were to be one, would be so here. I see I have a minute, but I'm happy to rest on that unless there are any other questions from your honors.
Thank you. Mr. Deering, we're back to you.
Thank you so much, Your Honor. I'd like to just start with the question of the so-called supposedly meticulous findings of Justice Madden regarding investigations. Here's what Justice Madden said, and I just want to preface it by saying we asked for a chance to answer the petition. The justice denied us that, saying it would serve no purpose. And here's what happened. She says, record 27, no indication that any governmental agencies investigated the actions of any police officer other than Officer Pantaleo. Here's what the record actually showed. The petition itself said otherwise. Here's what it said, quote, IAB investigated the role of each officer on the scene. That's record 83. The court dismissed that, saying that was just citing a New York Times article. I'm not going to follow that allegation from the petition, and I'm also not going to give the respondent a chance to answer the petition. What else did the record say? Record 264, 265, quoting and citing the testimony from the departmental trial. The investigation had at least, quote, 5 subject officers, interviewed all who were present on the scene, 20 police officers and about 20 civilians. That's 264, 265. Record 266, 267 refers to a statement, public statement of the U.S. Attorney's Office when it concluded its criminal investigation. It said it investigated all officers who participated in the arrest and stated could not prove that Pantaleo or any other officers, quote unquote, violated federal criminal law. That's at least 3 or 4 different places in the record where that so the meticulous finding from Justice Madden was contradicted in a way where she granted the petition on a motion to dismiss and didn't give us a chance to answer it. We could have put in a lot more on the investigations if we had been given that chance. The departmental trial itself includes a lot of material about the investigations from.
But didn't you, Counselor? You made a strategic decision not to answer, but to move to dismiss. So aren't you bound by that decision now?
No, the law says you should be given an opportunity to answer if the answer would be meaningful. The ground for denying an answer is it would serve no purpose. I submit when the justice is going to reject the petition's own allegations and then not give an opportunity to answer, that is an abuse of discretion and it's imprudent. Just to talk about a few of the other issues on the aid rendered, counsel says the only thing that the testimony says was there was a pulse check. That's not true. What the testimony says is an officer who arrived, ran over to the scene, who was also happened to be a trained and certified EMT, did the things that you're told you're supposed to do in this situation. Yes, you check carotid pulse, confirms pulse. He confirms breathing, watching the chest go up and down. He did both of those things. He says what you're supposed to say, which is call 911, and they did. And then he did the 4th thing cited in Deputy Commissioner Charles Maldonado's decision that she said followed departmental practices, policies by saying we should turn Mr. Garner on his side to facilitate breathing. And I understand that may seem, in light of how it turned out of what happened, it may seem inadequate, but it is a lot more than what Petitioner's Counsel is suggesting. And to hold an inquiry to repeat that testimony and just leave a question that the inquiry cannot answer about what more supposedly should have been done is contrary to James in both respects. These facts are not hidden from view, firstly, and secondly, that is quintessentially about a matter of judgment, alleged imprudence, alleged mistake, alleged error, not misconduct.
Thank you, counsel.
Thank
Your
you.
time is up.
Thank you.
Thank you. Thank you both.
Thank you, Your Honor.
People versus Randolph Jameson.
Good afternoon, Your Honor. Michael Confusion for the appellant. This is a fairly straightforward appeal, but it involves an interesting issue of the New York statute. We contend that under the statute 70.25, that the absence of the sentencing minutes in Mr. Randolph Jameson's case means that there's no specification by the sentencing judge under the law.
But are there other ways that we can determine what the sentence was? For example, the sentence and commitment form? Wouldn't that shed light on it?
I think it would shed light on it, Your Honor, but I don't think that counts as specification under the statute. I think because the sentencing minutes are the actual pronouncement of sentence under New York law, things like some of the documents, the people have submitted essentially documentation from the case that kind of goes all around the sentencing minutes, but they're not the minutes themselves. I think that could be certainly relevant to a reconstruction type hearing where the sentencing judge, who I believe still sits on the Supreme Court, could announce and say, I've reconstructed what I intended and I'm going to clarify what it is. And I think the documents the people have identified and that Your Honor has just now are relevant in that regard.
But there's just one document. I mean, to overcome the presumption of regularity, simply not having the minutes doesn't do it because there's no conflict that the minutes would create. And you don't only have the document that my colleague just referred to, which I think he said was the commitment sheet. You have the court worksheet. You have the litigation and the statements that were made. I think in the record there, you have the 2007 DLRA. There's across those documents, isn't there consistency that this was consecutive?
There is consistency, I agree, with respect to the documents that the people have presented. There's not consistency in the record with respect to the affidavit the defendant filed below. But I think beyond that, Your Honor, what I suggest or submit is that the specific 70.25 statute, when it talks about that it's a presumptive concurrent unless the court specifies the manner, I think that under New York law, specifying the manner means the actual pronouncement of sentence by the judge on the bench during the sentencing proceeding, and that alone is what counts as specification. The other documents—
Is that the case even when the first department has already found or recognized anyway that the sentences were running consecutively in our previous decision?
Yes, and I'll say this as to why. In both of the cases I saw from that this department has looked at, first of all, they looked at the direct appeal itself, which was from 1999. That the court decided that. I don't see anything in that decision where they address whether or not there was any kind of an issue of consecutive or concurrence, and they actually don't mention in that decision anything about whether it was consecutive to the previous attempted murder charge. On the 2009 opinion that Your Honor is probably referencing,
yes,
all the court is doing there is saying that the Supreme Court, under a resentencing to make it a determinate sentence under that reform of the drug law, doesn't have the power to revisit the determination of consecutive versus concurrent that the original sentencing judge had. But the appellate division in the 2009 decision does not say it was consecutive or concurrent. The court there is just saying the lower court doesn't have the power to redetermine it on a DLRA resentencing. So again, those are certainly indications. You know, I know that Judge Hong said in his decision, the judge really said two things. The first thing he said was, well, the defendant waived the issue because, as Your Honor has said, everything suggests that it was a consecutive sentence. But the things that Judge Hong pointed to were really, to be fair to the defendant, they were representations made by his assigned attorneys. It doesn't mean his assigned attorneys were wrong. They may be right, but I don't think they bind the defendant in the regard that Judge Hong said here. The second thing is, he said, well, the defendant waited to order the transcript of the sentencing minutes. There's a couple things that are a little strange about that. One is, I don't know exactly what happened to the sentencing minutes, but you would think they were probably before the court in the direct appeal, which was decided in 1999. And for whatever reason, they're still not seen to be found. But putting that aside, the defendant ordered his sentencing minutes in 2011. And in his affidavit, he says, I only knew, he basically said in his affidavit, when I got resentenced, it got changed to a consecutive sentence. And that's when I went ahead and proceeded to look into the issue. So I could see you're going to say something, Your Honor.
I was just going to ask you to wrap up because you have some rebuttal and you're over your time. But
the only thing I would say, Judge, is I think if you look at even the Paris case from 2004, where it says it's not enough to reverse a conviction, it's not enough to vacate a sentence. But the court does say, it basically said if you identify an issue to which the missing minutes are relevant, at least a construction type hearing is warranted. And in this case, 15 years of the defendant's life hinges on these sentencing minutes. So that would be, I would say, would be at least the remedy we would ask for in the appeal.
thank you. Mr. Yetter, sorry.
Yes, Your Honor, thank you. Justice Hong properly exercised his discretion in summarily denying defendant's CPL 44020 motion. As Justice Hong found, the defendant's argument simply defies logic. Defendant's own motion, the evidence he supported shows that in 1993, his 1993 sentence was ordered to run consecutive to his 1991 sentence. And that's supplemented by the evidence we also produced with our brief, including the Supreme Court worksheet and the pre-sentence report. And then it's defendant's now appellate claim is contradicted by the position he took in 2007 in the DLR-8 resentencing proceeding. And, to the extent there's a dispute about what this court thought of defendant's sentence in 2009, defendant asked this court to order his sentences to run concurrently instead of consecutively. So it's always been the case until now that these sentences have been consecutive. As defendant recognizes in his own brief, the mere absence of the sentencing minutes itself does not entitle him to the relief he seeks. The cases he cites all involve situations where there's a discrepancy between sentencing minutes and a sentence commitment form. So he's not entitled to relief on those grounds. To the extent he's now asking for a reconstruction hearing because we cited Paris in our brief and explained why he's not entitled to a reconstruction hearing 28 years or nearly 28 years after he was sentenced in 1993, we think there's just no good faith basis for that relief. I'm not sure that this court could order that relief since he never asked for it below, but there's simply, even if it could, no reason to do so. Unless your honors have any more questions, we would ask you to affirm.
Thank you. Mr. Confucione, did you say Confucione? I'm sorry if I've mispronounced it, but we're back to you.
You're close enough, Your Honor, and half my family pronounces it with 5 syllables, half with 4. So you're close enough. I would say this, Your Honor. I mean, obviously, the issue of waiver, I've already made my argument on that. If the court doesn't get past kind of what Judge Hong did, then I'm going to lose. And I'm also going to lose if you look at the statute and the court says, well, specification does not necessarily require or mean sentencing minutes. But I think the crux of my legal argument under the statute is that it does. That these other things, these Supreme Court worksheets, all these forms that people have produced, some of which, by the way, they produced only in the appeal. They didn't even produce them below. Okay, and I didn't object to it. But the fact is, those documents are not on par legally with the sentencing minutes. Sentencing minutes are a special thing under the law. That's where the judge pronounces sentence. And it also is because the statute is a presumption of concurrency. So for those reasons, it's really the government's burden to show that the judge specified in the manner in which the law dictates. That's only in the sentencing minutes, which at least would warrant some kind of a reconstruction hearing.
Thank you.
Thank you for hearing the case, Your Honors.
Of course. Thank you both.
Nice afternoon.
You too. Matter of the city comptroller versus the city of New York.
Good afternoon, Your Honors. David Scharf of Morrison Cone for the appellant cross-respondent, the comptroller of the city of New York. We're here to address the limits placed by the motion court on the scope of the controller's lawful investigation into the city's planning for preparation and response to COVID-19, which has cost the city over $5 billion and has otherwise affected the finances of the people who live in the city.
Mr.
So
Shah,
this,
please.
the standard under which the controller is moving is extremely broad here, and certainly inclusive of the documents that have been requested. How do you suggest that we limit this, or I guess why is the judge wrong in allowing and finding in the way he has?
There are two ways, Your Honor. First of all, the application of the privilege as the court applied to the specific communications between the deputy mayor and the mayor was incorrect for two reasons. First of all, the city waived the privilege. They came right out and they said that the deliberative process privilege, there were no privileges that applied. They, in fact, provided the deputy mayors as somebody who they were going to search. They repeatedly said that they would fully comply with the scope of the subpoena. Look at page 296.
Since there's only a limited amount of time, I actually would love to hear you speak about the merits of whether or not the privilege applies. And if it does apply, how would we make a determination or order a determination to be made as to the scope of the privilege? And, what would be required to make a determination as to a more nuanced approach to the privilege?
Sure, understood. So to the extent that the privilege hasn't been waived, Your Honors, I would say the following. The city did not meet its burden because its burden was to say something way more general than simply say there is potential harm that may come about pre-decisional information being disclosed. Because
Counsel, what's incorrect about the argument that if all of these documents were disclosed in these type of situations, it would hamper the ability of top-level officials to speak freely about these issues in a way that they would not be able to if all these documents were going to ultimately be disclosed to the public?
Because the deliberative process, as well as any privilege that they would seek to invoke, is overridden by the public interest in transparency. The purpose of a lawful investigation of this nature, when you're dealing with something of this order of magnitude, gives great deference and weight to investigation and transparency. Deputy Mayor's affidavit didn't go into detail, didn't provide the court with even a privilege log, a basic privilege log.
Let me follow up on that then, because let's say we find out for purposes of argument today that the privilege does apply, and we're then left with the issue of how to apply the privilege and what would be the proper circumstances. You're saying that it should be a balancing test. How are you suggesting that balancing test would take place, and how a court would make a determination as to whether or not particular documents were or not privileged?
Step number one, like every other privilege situation, there needs to be a privilege log that's provided that provides detailed information sufficient for the court to conduct an inquiry. If that is insufficient, in-camera review, courts have said, those would be appropriate here. The deputy mayor and the city did none of those things. They just simply said, we're afraid. Look at an article where the article didn't even talk about violence against people who were decision makers. They just waived a broad concept. It was an abuse of discretion for the motion court to simply adopt and accept that without holding the city to its burden to demonstrate actual and true harm that may occur, to do the balancing test where the primary factor, to the extent that the privilege even applies, is transparency in a lawful investigation. This is not a situation. Judge Singh, I see you're talking, but we can't hear you because you're on mute.
Sorry about that.
That's okay.
Do you have any sense, and you may not, so what is the universe of documents we're talking about with respect to this privilege law?
We don't know because all we kept getting was slow rolled by by the city. They first came out and said, we're going to get you those documents. Here are the ways we're going to search for it. We're putting in deliberately broad parameters in our electronic search engines. We're going to apply it first to the FDNY and then to the NYPD. We're going to do it then to health and hospitals, and we're going to get to the deputy mayor.
So it sounds like it could be millions of documents, right?
No. So the short answer is it shouldn't be millions of documents, because and the burden shouldn't be overly shouldn't be too much, because what the city said in the early stages was they had a budget for it. They had search terms that they were going to test. They had allocated all of the resources that were necessary for electronic review. This wasn't going to be a resource constrained issue. Right up front, they said they were going to fully comply and laid out a plan how they were going to do it. The whole concept that this was a problem, that this was a burden, that this was going to be too much, came only after 8 months of them slow rolling and the controller saying, I am conducting an investigation. Give us the information, give it to us by a date certain. When they didn't do that, we went to court to enforce the subpoena, which came
Counsel,
after.
this is Justice Moulton. There were allusions from the city, I believe, that the pandemic was happening, people weren't showing up, weren't able to come to work. It was harder to do remotely the task that was necessary. So they did give that heads up to you all.
Yeah, they did, and at the same time, they said they would fully comply. They gave us dates. Not a single date did they meet. They agreed that they would provide search terms for the custodians that included the deputy mayor. They never came with those. They said they would give them to us by August and then October, and didn't do that. We would not be here if the city had made good on what its commitments were. Instead, it then came back in its papers to the court and said, see you in November. See you in November of 2021. The city is playing politics here and not allowing the comptroller to do its lawfully authorized job of doing an investigation, because the medical experts, the pandemic experts have said, while we may be getting over COVID-19, we avoided SARS, we avoided MERS. There was a real threat that the city knew about going into COVID-19 that public health officials had previously put the city on notice of. What they were planning, what they were doing, what decisions were being made by the government in terms of its operations when it said close the city, close businesses, how it's going to affect the finances to make sure we don't have a repeat of the catastrophic effect if we don't invest.
Thank you, Mr. Sharp. If you just wrap up your sentence.
Yes, if we don't investigate what happened in the past, we will never be and have the transparency necessary in order to plan for the future. And the future is right in front of us.
Thank you. Mr. Schwerter?
Schwader, may it please.
Sorry. And also you have a cross appeal, so please include that in your argument.
Thank you. Yes, Jeremy Schwader for the city. And I'd like to start, I want to address the privilege, but I'd like to start with the comptroller's authority to even do this.
I understand that is the main part of your appeal, but I would like to ask a question about the privilege first, because I just want to make sure we don't lose that.
Absolutely.
I'm going to ask you to assume the same thing. Assume that the court is going to find or would find that there is some kind of privilege and that the balancing test required by the law has to be done. The court below didn't seem to really do any explicit balancing test. It just said we're not going to include any documents to or from the mayor or the deputy mayor. Is that permissible under the relevant case law, which talks about this privilege, and that you really have to do a specific analysis as to these documents, whether or not they do or do not come under the privilege? How can we uphold or make that consistent with what the court did below here, which did not do a balancing as to individual documents?
Well, I disagree that the court didn't do a balancing. The city didn't come in and say the only things that you should withhold are the mayor and first deputy mayor. That was the court's determination after looking at the people who were involved in this. And the court said, you know what? For the top two decision makers. That's all I'm going to allow you to apply the privilege to. Those are the only people who matter here in terms of the danger that.
I'm sorry, how can the question I have for you is how can the court make that determination without having some type of review of the documents involved or a privilege log or an in-camera inspection? What's the basis for the court to be able to just make a decision? We're just going to exclude a group of documents like that.
Well, this is where we were in the case, of course. The comptroller wanted to move this forward. They brought this petition. It was heard very quickly. Of course, at that point, the documents weren't all collected. So I guess that one option for the court would have been to say, let's wait a few months, collect the documents, and then come back to me. They could have done that, but the court wanted this, I think, fairly to move quickly. And it said, look, I see the evidence you've put in, and I have decided that the top 2 decision makers in the city, and that's it.
But no, counsel, it's not. I'm sorry to interrupt you, but I'm reading from his decision right now, from Judge Frank's decision. It's communication between the mayor, Deputy Mayor Houlihan, and others. Who are those others?
No, it is. I believe it is any email sent or received by them is what it is. It is those. It is just those people. So if they're on an email that involves others, it would mean they're on that email. But it's just for those people.
So, counsel, let's say I don't disagree with what you're saying now. It's between those 2 and others. So the others means the others in communication with those 2. But how can we, as an appellate court, analyze whether or not the court below is correct without knowing what the documents are, what the universe is? How could we make that arguably nuanced determination that's required?
I'll have 2 answers to that. First is the comptroller has never, not today, not in its briefs, ever said, here's why we need those emails. They have actually never done anything to counterbalance what we have put forward and say, actually, that's wrong because those emails are important for whatever reason to further our investigation. They've never said it. But second of all, I go back to, we're talking about an abuse of discretion at the time the court ruled on this. It did what it had in front of it. The documents hadn't been collected. If this court wanted to say, go back, consider the emails, gather them, look at a privilege log. Let me answer another question that I think Justice Singh asked, which is, there are going to probably be a lot of emails. I don't know.
Like how many? Let's talk in numbers. You must have some sense, right, already?
Your Honor, my understanding is that the documents from City Hall have not been collected. Other agencies have. City Hall is not, so that it's probably going to be a large number. But if it's going to be a large number.
Can you give us an example of the other agencies as a reference?
I believe that the fire department, emergency management, I don't want to make a misstatement. It's possible H&H. This is one of the things I wanted to get to, which is that none of these issues were raised in Supreme Court. They never asked for a privilege log.
Let me do something now then. Yeah. What is your position right now as to the appropriateness of a privilege log being ordered?
I would say that if you can overlook the fact that this court is now engaging in the type of discovery consideration that was never raised below, never brought up, and that would never really be a proper appeal standing on its own, because it's not the type of question that could even be brought as an interlocutory appeal to this court. I would say that's fine. I would say if they want to have a privilege log, but we still need to have a reasonable amount of time to gather the documents. And it's probably going to be a large number. And the reason it's going to be a large number.
But what is a large number? What is a large number?
I really don't know, because they haven't been collected. But this is not the.
A large number. It just is okay.
I understand, but this is the problem with not raising it below, is that this is not the time to start developing facts. And I can't. I literally cannot start.
Counselor, I think what my colleague originally was getting at, the documents themselves or a privilege log, isn't that part of the balancing that the judge should have initially made? In other words, it was your burden to put before the court sufficient information for the court to then do the balancing and come to the determination it came to.
I think that not in the way that this case moved. But if that's the way that this court wants to go and say, send it back, consider a privilege log, I just want to say my guess, and again, I can't answer the number, is that it's going to be a large number because of the scope of this
Well,
investigation.
a large number, over 1 million documents.
I cannot know. I cannot know how many emails are going to be involved. I
So then it
simply
may
do
not be a large number. It may be a manageable number.
I don't even know what manageable means, but
I don't know what large means.
Well,
I don't know
manageable
either.
numbers in
We're
my
both in the
perspective
dark.
are
I'm
numbers
looking
that
to
we
you
dealt
for
with
that
in the
answer.
commercial division. I mean, we dealt with those kinds of issues. I mean, you do ESI and you narrow it out through privilege logs, et cetera, no?
That's fine. Again, this is a very unusual appellate conversation when we have no facts to go on, no request for a privilege log below. It's hard to say there was an abuse of discretion when nothing was asked for. The court certainly didn't abuse its discretion in not doing something that it wasn't asked to do.
In the record below, was there ever a request made by opposing counsel for a privilege log or in-camera inspection of the documents?
Never.
So how did the arguments come up in terms of the privilege and whether or not the privilege should or should not apply?
Well, we asserted a privilege, Your Honor.
So what was there? Was there only response below? There is no privilege period, and the only thing being litigated whether there was or was not a privilege, not if there is a privilege, how it would actually be applied under the circumstances of this?
That is correct, Your Honor. And it's fine. I'm actually surprised today at the argument I'm hearing, because the primary thrust of their argument was that as a matter of law, there shouldn't even be a balancing test. And they've kind of, what I understand is maybe they've given up that argument because it's really, there's no basis for it. I mean, we've had 90 years of this privilege.
Is part of your argument that it's not, these arguments aren't really preserved at this point for us to be issuing decisions about privilege logs and in-camera inspections because the record wasn't developed adequately enough below for us to consider it?
Absolutely. I mean, I'm actually surprised that this is the way this conversation is going, because it's maybe 1 or 2 lines of their brief. It was never raised below. I certainly don't have the facts available to be able to answer many of the reasonable questions you're asking about the scope of this, because it was never developed below. It's just not part of the case. But I'd like to go to the authority if I can. Because I think it's important. I think it ties in with this idea of there being a lot of documents. The reason that I suspect there's going to be a lot of documents is because this is an investigation which is super broad, not targeted towards finances. The comptroller himself in this case said this is not a typical investigation. We agree. This is a broad and diffuse investigation into the information that the city had and the dissemination of that information. I know that my colleague has said this is about the planning for the pandemic. My belief is that there are many different types of investigations into the planning that would be within the comptroller's authority.
Can I ask a specific question about that then? Because I agree, it is a very broad investigation, but when you look at the language of the city charter, it's very broad. I mean, all matters relating to affecting the city's finances without limitation. So that's a very broad mandate for the comptroller. And how do you to get around that?
It doesn't actually say without limitation. It just says all affecting or relating to.
I meant there is no limitation on it.
I see. Yeah.
There's no limitation on how it's defined.
But there is a limitation, and it's the finances. And this court has actually already addressed this issue, because in Alouette fashion says a lot about how the court should consider this. And I think it's pretty relevant that there is no case out there, and my colleague has not cited any, that has ever affirmed this type of investigation that is this divorced from something connected to finances.
But I don't understand that. It's just that what I've seen all over the world, the pandemic and finances go hand in hand. You turn the spigot off, finances cut down, and the city's tax base goes down. So I'm not sure I agree with you on that there's no connection between the two, because that's all we've been talking about for the last year and a half.
Well, that's what Alouette fashion speaks to, because the dissent in Alouette fashion says, how could there not be a connection? And in effect, these are tort claims that are going to be worth $1.5 billion in 1986. So, and the majority disagreed with that, and so did the Court of Appeals. And they said that's not the way you're going to create the connection to the finances by just saying downstream there's going to be a lot of money at stake. It has to be something more concrete. I think you can see that from all the cases, every single case that has confirmed this type of investigation has involved something much more concrete than we have here. The legislative history shows an intent to not have it be so abstract as it is here. Because otherwise, if you take that view, then everything relates to the finances, because you're always going to be able to make a downstream connection to finances in some way. This one is the comptroller cannot point to any investigation it's ever done that has the scope of this one and the remote connection to finances that exists here.
Thank you. I'm going to move back to Mr. Schreff.
Thank you.
Sure. So thank you.
Mr. Schreff.
Thank you.
A quick question before you go ahead, because your opposing counsel, to Mr. Shaw. Your opposing counsel has made an argument that the issue of privilege logs, in-camera inspection, none of that was raised below, none of that was argued below, and that you're bringing that up for the first time in appeal, which is inappropriate. What's your response to that?
The response to that, and to sort of think about it, as far as we're concerned, from the controller's perspective, this court can simply decide the trial court, the motion court got it wrong, period, full stop. And the reason they got it wrong was because the burden was on the city to demonstrate that a privilege existed, and if it existed, that the balancing test that is required by law when there is a privilege comes in its favor. The city did not do that, period, full stop. It is the controller's position that based upon that, this court can simply say, we're done. City, you did not meet your burden. But
why can't we let, let's say again, assuming arguendo, we're going to find that a privilege does apply and we have to determine the scope. Why couldn't the court just do what the court did below, say this privilege does apply, but take the extra step of saying if it doesn't, it's not encompassed in your view by the privilege, it doesn't get turned over. It is encompassed by the privilege. Vice versa. It gets turned over.
So we can't blame the court below. The court below committed error, but the blame for this has to start with the city. It didn't meet its burden. Okay, the trial court below simply said, okay, this feels right and feels good, and didn't do the job that it was supposed to have done, which is.
And I'm going to ask one last question. I'm sorry I keep interrupting. Let's say we find that the court below did correctly find that the common interest privilege does apply on some level. If none of the documents were before the court, none of the documents had been collected, and you were going ahead with these arguments, how could the court do the kind of balancing test that you're now arguing needed to be done when none of the documents had even been collected at that point?
That's why the city didn't meet its burden. That was the error that the court made. If you look at page 92 of the record, where the answer is, this talk about massive amounts of documents, the city admits that by November 18th, it produced approximately 30,000 pages of records. We're not talking about millions of pages of records. The city had a burden to come before the trial court and say, we have done the review that we undertook to undertake back in July. And here are the custodians that we looked at. Here is the numerosity of documents. Here are the issues that are in there. The city didn't do that. Therefore, error was committed by the court. Court committed an abuse of discretion. Now, if this court wants to fix it and give the city a second chance and say, you know what, there is a privilege, then the city's got to go back and this matter has got to get remanded and the city has got to do the review quickly because they've had 8 months. They come to this court saying they haven't even done the review yet. It's almost a year later since the request for information was issued. This just goes to show their bad faith. They didn't intend to do this. They're hoping to string this out. And they have to go back to the court and say, here's our privilege log, here's the documents, things that they should have done and that they undertook to do last summer. That's why there's error. That's how this court should address it if this court wants to give them a second chance. Frankly, we don't think this court should give them a second chance. They had their chance. They missed it. They blew it. And this has nothing to do with waiver and estoppel. It has to do with the basic fundamental precept where somebody comes to a court seeking to quash a privilege and raise a privilege, they have to do more than the city did. The city did nothing except simply say, broadly, oh my goodness, the world's coming to an end.
Mr.
Well, the
Scharf?
world
Thank you,
came to an
Mr.
end.
Scharf?
Oh, there's a question.
I'm sorry. I just have one question. Can you address your adversary's point that your investigation falls under the Alouette case?
So it doesn't. The Alouette case is completely different. The Alouette case was where the investigative subpoena was looking to go around and get documents from a city agency that couldn't from non-city agencies. These were requests that they were going to get subpoenas. Let me say it differently. The controller was going to plaintiffs to get information from them that the city itself could not get under the governing law provision. This was not a subpoena of a government city agency, number one. It was going directed to private litigants about their litigation with the city. It was found by the court to be a circumvention of the city's inability to get this information from the plaintiffs. And it involved a completely, let's call it esoteric concept of damage and harm and claims that may come into the future and being, yes, that is attenuated. But if one looks at the Golden versus Koch case, and we look at the Golden versus Greenberg case, where the Court of Appeals has addressed the issue of the scope of the power of the controller, this court understands very well we have the power, and this affects the city fisc. And if you look at the arguments that the city has made, that just goes to tell you how weak they actually believe their position. They try to resort to legislative history, which doesn't even come into being, and they try to redefine the issue as financial transactions. Look at their briefs. They call it financial transactions, but as this court has already recognized in this argument, that is not what the authorizing statute that the voters of the city of New York voted to give the power to the controller to look into all matters relating to or affecting the finances of the city. There hasn't been.
Thank you, Mr. Scharf.
Thank you, Your Honors.
Mr. Schweter?
Yeah, Your Honor, I have to say, I think it is actually inappropriate to come in and say the city didn't do all these things that they never said below we should have done when we would have had the opportunity to do them below. This is classic waiver. This is not a legal issue. If they're saying we needed to come in and show more, then they needed to say it below, and then we would have had the opportunity to try to do what they're saying now, which is really not part of their briefs, not part of the record below. And I just don't think it's really correct, really procedurally at all, to come in and say the city has failed in doing this, this, and this, when you have never said such a thing before, and it could have been remedied below if given the opportunity. So, I mean, that to me is really fully waived. If this court, I think that the comptroller has another option here, which is that if you affirm on the privilege issue, and this becomes an issue later, this is certainly something that the comptroller can go to Supreme Court and say, we'd like you to reconsider because here's what's happening. And the Supreme Court is the one that's supposed to govern its own discovery procedures, not this court, and particularly when nothing has been ever developed below for this court to even consider or decide. I mean, I'm honestly very surprised by all the questions I'm getting, and I'm sorry I can't answer them, but they've never been raised before. They're not part of the record. I don't know the answers to many of the questions you're asking because the comptroller never made it a part of the case. That's really all I need to say at this point.
Okay, thank you very much. Thank you both.
Thank you.
People versus Matthew Williams.
Yes, Your Honor. May I proceed?
Yes, please.
May it please the court, good afternoon. I'm Nick Telehi, a law intern with the Office of the Appellate Defender representing Matthew Williams. A prosecutor commenting on a defendant not taking the stand to testify is among the most serious and egregious constitutional errors that a prosecutor can make. And in Mr. Williams' case, that comment wasn't merely oblique, but was explicit. Now, in summation, the prosecutor explicitly references that Mr. Williams didn't testify for the jury, and placed that comment right in the middle of an argument where that prosecutor is claiming a lack of evidence on the record to support the defense.
The judge gave a charge. The judge gave a curative instruction, I believe, or at least in her charge, indicated that the burden doesn't shift and was quite clear on that. Was that sufficient to take care of any issue there may have been? I mean, the jury is supposed to listen and follow that.
No, Your Honor.
And I will say this, as much as the prosecutor should never have commented on anything with regard to any burden, it was an accurate statement of the law.
Let me try to address each of those things. First, no, we don't believe the judge's later charge of the jury sufficiently cured that. When we look at the case law, it becomes clear that both this department and the Court of Appeals is concerned when a judge first certainly overrules an objection, but also when a judge doesn't immediately cure it. It's because there's a concern that it gives standing to that sort of illegitimate argument that the prosecutor makes. Then to the second part of your question about whether it's an accurate statement of the law, though at first the prosecutor does say, yes, you can't use this against him, because of the context of where that falls with the prosecutor's argument, it's not the same thing as the judge instructing the jury later. When the judge is instructing the jury later, the judge is saying, you can't use this in deliberations, you can't think about it, you can't do it. But when the prosecutor is making an argument, particularly when the prosecutor is making an argument discussing a lack or an alleged lack of evidence on the record for the defense's theory, it becomes clear that the prosecutor is putting that choice not to testify directly in the context of a lack of evidence. And that's where it becomes especially egregious and especially improper. And that's exactly what the prosecutor said. The prosecutor said, you absolutely cannot hold it against Mr. Williams that he did not testify, but defense counsel can't essentially testify that defendant was defending himself.
So in other words, wasn't actually what the prosecutor doing responding to defense counsel's summation in that instance? And isn't that proper?
In this case, Your Honor, no. First, it's not proper for a prosecutor to comment on a defendant's choice not to testify at all, which is what this prosecutor did. But second, if the prosecutor wanted to talk about a lack of evidence on the record, she could have just said that. She could have just said, you heard this is what defense counsel argued, and there's not evidence on the record that you heard today to support that argument. And so that sort of gets at one of the respondent's arguments where respondent says, well, she was just instructing the jury or helping the jury along to make sure that they wouldn't draw that, that type of inference. In this case, reminding the jury that Mr. Williams did not testify right before making that is essentially a circular argument. Prosecutor had that opportunity to avoid talking about Mr. Williams' choice not to testify, did it anyway, and then compounded it by essentially saying defense counsel was testifying for him, which is not something that the record supports, and it's not something defense counsel did. But when you look at the record, both for openings and for summation, defense counsel's arguments were all appropriately couched in the evidence that was on the record. And so when you look at it, defense counsel's arguments are about the 911 call that the complainant raised, where you can hear the complainant in the background shouting at Mr. Williams as the complainant chases Mr. Williams down the street.
What about the comments? What about comments with respect to the chain and that kind of stuff? Suggesting maybe there was self-defense? No?
Even those arguments, Your Honor, are based off of the record. It's because based on the record as it existed at trial, the jury was able to hear the complainant shouting at Mr. Williams, mother effer, you're never getting to that fight. You ain't going nowhere. Where are you going? Those sorts of things. It's further backed up by the bystander 911 call that the jury also heard, where the jury heard a bystander say, not that Mr. Williams was attacking the complainant, but that the complainant was holding Mr. Williams down, beating him against the street. And so based off of the evidence that existed at trial, defense counsel was able to make a proper argument based off of that record that Mr. Williams was attempting not to attack or engage in any sort of violence, but rather to get away from this complaining witness. And so because of that, the prosecutor's argument was not legitimate and was not a fair response, as respondent argues, to the statements or to the fair argument that defense counsel made. Instead, what the prosecutor does here is put this argument about what the prosecutor's claim is a lack of supporting evidence directly in the context of Mr. Williams' choice not to testify. And so when she did that, she crossed the line from what could have been a permissive summative argument to egregious constitutional error. And it's an error that the judge then would go on to compound by not sustaining defense counsel's objection and providing an immediate curative instruction. And so by not, thank you.
Mr. Yetter?
Yes, thank you, Your Honors. Just first of all, the defendant's entire argument is unpreserved. If you look at 169 and 170,
such a basic argument that it doesn't need to be preserved, where a prosecutor talks about the defendants not testifying? I mean, burden shifting is one of the, the most egregious issues in a criminal defense case, and the prosecutor directly violates that.
Well,
for no
Your Honor,
reason, really, because it was quite easy to address what the defense attorney was doing. Either that testimony wasn't in the record, or the defense counsel was testifying, or the defense counsel is speculating. It's not based on the evidence. Any one of those things would have been sufficient.
So, Your Honor, I guess 2 points, and I don't want to mischaracterize your question, but I don't think this is the type of error that is a mode of proceedings error that would be outside the realm of requiring preservation. Certainly, many constitutional errors require preservation, and we believe, based on the cases cited in our brief, that this one did. And if you actually read, how this exchange unfolded, the defendant objects, right, and basically the court says, when did he say that? And then the prosecutor said he just argued that in his closing. And so what they're talking about, we believe, is the characterization of defense counsel essentially testifying that the defendant was defending himself. At the very least, it's unclear as to what the basis of defense counsel's objection is. And we would also submit that defense counsel at the trial did not think that the prosecutor, as my adversary says, was cynically instructing the jury accurately about what the right to remain silent is, but at the same time suggesting that they should disregard that instruction.
It is sort of a debate tactic, or whatever that is, when you don't say I won't say that I'm talking about the defense attorney not testifying, or the defendant not testifying, but you obviously, in saying it, just did it. And I can't remember the name for that debate technique, but essentially that's what happened here.
Your Honor, this was all couched in the description of defense counsel's argument. As Justice Singh said in one of his questions, the prosecutor was responding to this idea that was developed through defense counsel's opening statement and summation that his client, the defendant, was somehow defending himself from this bigger, younger, unhinged, raging guy, when in fact there was no evidence at all.
That's what he says. What's in the record is that there's in fact, I think one of the people the bystanders who gives the 911 information or something says there's this big guy sitting on another one punching him. He's got a green hood on. I'm not sure who's here, who's being injured. So it wasn't that much of a stretch. Whether or not the defense counsel testified to something in a voice of the defendants is something that could easily have been addressed without talking about the law, which neither the prosecutor nor the defense attorney is supposed to be doing. Isn't that the judge's purview?
Yes, it is the judge's purview. I guess two points to that. One is that the evidence clearly showed that caller, who identified himself as John, only saw the end of that altercation, and his phone call was consistent with Durar's. I'm sorry.
Saying that what the defense was doing with the evidence that was given was a fair argument, and it was the only argument. And if the prosecutor was going to challenge it because it was a stretch, because he shouldn't have been testifying, that would have maybe been stronger to say the defense attorney's not supposed to be testifying.
Well, respectfully, Your Honor,
about the case law, not the case law, but the law, which is not necessary. Anyway, you go ahead and finish up.
Well, Your Honor, even if I don't have you on that, we believe that if you find error with respect to what was said by the prosecutor,
you don't know what you have me on. I'll say that. Don't assume what you have me on.
Okay, I apologize. All I meant to say was that even if the court were to find error, we would urge the court to find that error harmless in light of the overwhelming proof of the defendant's guilt in this case. You have the complainant's testimony, you have the phone calls that provide sort of a running account of what's happening, you have the recovery of the tools by the police officer, and we believe in this case that evidence was overwhelming. Unless your honors have any other questions, I'll rest my brief.
Thank you.
Thank you.
Back to you, Mr. Nursey.
Teleki, Your Honor.
Oh, I'm sorry. So I thought it was Teleki, but then I see Nursey at the bottom. But
Yeah,
okay,
no.
go ahead. I understand that's the attorney who's, okay.
Just 2 points for rebuttal. First, here, I want to address the preservation question. This argument was preserved at trial. The purpose of the preservation rules is to make sure that the trial judge has the opportunity to pass on the issue and then potentially avoid the sort of improper argument and hear it immediately. And here that purpose was met. It's met because as soon as the prosecutor made the improper argument that invoked Mr. Williams' right to testify, defense counsel said objection. The trial court asked the prosecutor to explain. The prosecutor erroneously essentially argued defense counsel opened the door, and then the judge overruled that objection. And so by doing so, the prosecutor's comment, along with the judge's actions, complete the record, and so this was preserved. The second point I want to address briefly is the harm that occurs because of this error. Because commenting on silence is a constitutional error, it has to be established beyond a reasonable doubt that the improper comment didn't even contribute to the conviction. That can't be said here, and contrary to respondent's position, the evidence at trial was not overpowering enough to meet that standard. Essentially, this part of the argument dealt with how Mr. Williams was using the chain, whether it was lawfully and in a manner that could cause serious physical injury or death. And what the prosecutor said was defense counsel was essentially testifying for Mr. Williams that he was defending himself. But the jury heard the entirety of the complainant's 911 call, where you can hear the complainant following and shouting at Mr. Williams. They heard the bystander who called 911 later and says he's watching the complainant actually attack Mr. Williams, not the other way around, that he's on the ground, that he's incapacitated, holding him down until the police can arrive. Now, defense counsel's argument to these points was legitimate. It's based on the record. And so to accuse defense counsel of essentially testifying to those points and then put that comment in the context of Mr. Williams' choice not to testify, it constitutes a comment on silence, an egregious constitutional error. And as a result, we would ask this court to reverse Mr. Williams' conviction. Thank you.
Thank you. You are a law intern, hopefully to be admitted soon, I hope.
That's the hope, Your Honor. Just graduated, so bar is the next step.
Oh, okay. You haven't sat for the bar yet. Okay, well, excellent job. Good luck. Excellent, both of you. Thank you very much. This concludes oral argument for today. Court is adjourned. Thank you, everybody. Have a good evening.
Thank you.